Well, good morning or good afternoon, wherever you are. People are linking in from both sides of the Atlantic for this webinar. I am delighted to welcome you on the one hand, and also really very sorry. My name is Jonathan Chamberlain. I'm a partner in the Labour Employment and Equalities team of Gowling WLG. I am joined by colleagues from Dublin, Paris and Frankfurt, who I'll introduce in a moment. And we're going to be talking about life after Brexit. You have joined us because you or your organisation are regrettably thinking that you might have to move, leave probably London, and it's a question of where you're going to land. Now, we imagine that you will have already asked Google some basic questions about what's it going to be like employing people in any of these cities? How easy is it going to be to hire people, to manage them? And the aim of this webinar is to put you in touch with people who know, so that you can go beyond and behind the Google answer and get a real sense, a real flavour of the comparative employment law environments in each of those great cities. So what I want to do now is introduce you to today's speakers, and indeed I will ask them to introduce themselves. In Paris, we have my friend and partner Valérie Blondeau.
Hi everyone, as Jonathan said, I'm Valérie Blondeau, heading the employment team of Gowling WLG in Paris, and have an extensive experience of working with international companies who try to either build a business in France or leave France because they think it's no longer possible or viable. So happy to discuss around these various themes in this webinar.
Thanks, Valérie. And over to Frankfurt. Annette.
Thank you, Jonathan, and hello, everybody. Yes, my name is Annette Knot. I'm heading the employment team at Arneke Siebert, and I'm actually also a real local from Frankfurt, the city of the European Central Bank. But we have also offices in Munich and Berlin, and I try to do my very best to convince you that German employment law is not as bad as its reputation. Thank you.
Thanks, Annette. And then over to Dublin for Melanie and Ian.
Hi, Jonathan. This is Ian O'Herlihy and Melanie Crowley. I'm a partner and chairman of the Employment and Law and Benefits team in Mason, Hayes and Curran, and Melanie, beside me here, is head of our team. We have the largest employment and benefits team in Ireland, and we deal very frequently with UK HR managers who manage their operations in Ireland from the UK.
Thank you very much, Ian. And if I can echo and repeat that for all of our speakers today, you are all people with whom we have worked closely, and I know from my own experience just how good you are at explaining on and advising on the various issues that our clients face in your cities. So what we're going to do is we are going to look at three topics over the course of the next 55 minutes or so. The topics that all of you in our experience are needing to know more about. We're going to look at how easy it is to employ people on the terms that you want to employ them, particularly senior executives. What are the constraints? What are the opportunities? We're then going to turn to ending the relationship and how easy is it to let people go, particularly in the context of do you have too many of them or are they not performing quite up to scratch? And then finally, and this is the one that we'll probably spend the least time on, but it has come up as we've had conversations about this. We're going to look at outsourcing, as the UK listeners will know it as TUPE, and of course there are equivalent local manifestations in each of our cities, and it works itself out surprisingly differently. So that's what we're going to be covering. We're not going to be talking specifically about immigration, although I hasten to add that all my colleagues can ask those questions, or they have colleagues who can answer those questions for you if that's what's particularly relevant. We're assuming that you're going to be able to get the people into the country that you need to get in, and it's a question of what you do once they're there. So let's kick off. How easy is it to employ people, particularly senior executives, on the terms that we want to employ them? Now, I could slightly cheat here by going over to Dublin because of the similarities there that you'll hear about in a moment, but I'm not. I'm going to start off, as Monty Python would say, with something completely different, and ask Valerie, how easy is it to employ people in Paris?
Yeah, it is totally, well, it is not totally, but it's slightly different from a French perspective to employ people, and specifically when it comes to the terms on which you want to employ those employees. So to make a long story short, because labor code is about 2,000 pages in very small font, so I'm not able to summarize that in the couple of minutes I have. But in short terms, the things that you have to keep in mind when you want to employ someone is, A, you don't have necessarily to have a written employment contract. This is not mandatory. So this is something that is very different from what I see with my UK colleagues. Also, it is still highly recommended because everything is not in the labor code. Some of the provision that you need to have to make sure that the relationship is going to be as comfortable as you want is included in collective bargaining agreements or internal regulation within the company or company level agreement signed with unions. So it is recommended to have this employment contract written to include some specific clause as non-compete or trial period or specific requirements as regards security or confidentiality or working time frame. As I said, it has to be compliant with European regulation, nothing specifically new in this respect for you, French labor law and collective bargaining agreements. There is about 500 collective bargaining agreements in France. I don't know all of them by heart, but a couple of them still. But it is something, it's the first question that someone will ask you if you want to hire someone in France. What is your activity in France and what is your collective bargaining agreement? Because that will put the frame for everything and specifically about working time. Remuneration is something that you will have to think about. We have a minimum wage in France, which is 1,580 euro gross per month. And above that, there is some scale in various collective bargaining agreements with minimum wages for every category of employees. So this is something that the employment contracts will have to be compliant with. Executives is something kind of special, specifically in terms of working time, because we have something very innovative and special in France about this possibility of counting working time for executive with days of work instead of hours and seconds, which is something that is only implemented in France since 2001, which is a great new thing and still innovative and still work in progress, to be honest. But this is something really interesting and really flexible for every company, but very interesting for international company who are not supposed and not very happy to be obliged to count hours and overtime on every days on every week. But this kind of frame has to be in collective bargaining agreement or union side company agreement to be implemented in employment contract. So this is, in a nutshell, what you have to know when you want to hire someone in France. Just a quick comment on gross and net, because this is a question you might have with your correspondent in France. We have social contribution to be paid on top of the salary, 40% for the employer and 20% for the employee, which means that basically for 1,500 euro gross monthly salary, the net for the employee in his pocket before tax will be 1,200 euros, and the cost for the company, social contribution included, will be 2,100 euros. So that's the major difference that comes to a discussion sometimes when you want to hire someone. And this is basically the very, very short summary of hiring people in France.
Thanks, Valerie. So if I could make that even shorter, and looking at this from the UK perspective, what's really interesting for us there is how relatively unimportant in one sense contracts of employment are. They are, of course, the key document in the UK, not nearly so important in France. You don't actually have to have them. But for your senior people, you probably will want to have them to cover what we would consider to be some quite important stuff. Also, note that the working time rules do apply to senior executives, which of course in the UK almost everybody opts out, but that they are measured in a relatively flexible way. And certainly in my experience, Valerie, I don't know if this accords with yours, there isn't any problem with senior executives having to work short hours, is there?
Definitely not. Definitely not. You're right.
So if that's the situation in Paris, what does it look like in Frankfurt, Annette?
Thanks, Jonathan. Well, to answer your question, how easy it is to employ people, I would say it's very easy, but that might be because I'm a German employment lawyer. Well, there are some similarities with France. Also, we have many written laws. We don't have one labor court, but various laws. And that's also the reason why, compared to the UK, our employment agreements are rather short. They sometimes only refer to the respective legal provision. And we also don't do, like the definitions, I know from many UK contracts, just because the definitions are in the law. There is no obligation to have a written employment agreement, although it's very expected by executive employees, in particular because many times, you do also a bonus agreement, and this is not regulated by the law, so that's also an important part of a German employment agreement. There is no need to get any approval to start an employment, so from any governmental organization or so you just fix the terms and conditions with your employee. Hopefully they are within the law, and then you do the contract. All employment rules apply to executive employees. There are not many special rules for executive employees unless they are really, really highly ranked in the management, like having the power to hire and fire. So all rules regarding working time, vacation, and so on would apply to these employees. Difference to France, or one of the major differences, is that collective bargaining agreements do not play such a major role, in particular for executive employees. They would not apply. So you are basically free to negotiate the terms and conditions for the employee. The minimum wage is lower than in France. We have it, by the way, since 18 months now, so it's pretty new to us. It's €8.84 per hour, and also the social security contributions are lower. They reach a maximum amount for the employer of €13,000 a year, which comes to maximum of 20% of the gross salary of an employee, up to a maximum annual salary, so that makes it to 13,000 per year. So basically, it sounds like being a little cheaper in Germany. Once again, no need for any approval from governmental organizations, but now the big but is coming. We have one famous body in Germany, and maybe some of you have heard about it. It's the Works Council. I don't want to start talking about Works Council now, just to let you know there is no obligation to have a Works Council. The employees have the right to elect for a Works Council, and once they do so, you have to respect the rights of the Works Council. And in Coming back to the hiring process, if the company has a Works Council, you need the approval and the okay from the Works Council to employ somebody. So that might be from time to time an issue, but to let you know, it's very easy with a very standardized application to the court to replace the missing agreement of the Works Council if this happens. So that's it from my side.
Thank you, Annette. So again, we learn that the written employment agreement isn't nearly so important in Germany as it is in the UK, although you rely less on collective bargaining agreements to underpin the employment relationship than you do in France. Something that Valerie mentioned, Annette, which I'd be interested in your take on. What about things like confidentiality and non-competes? Where would they fit in?
Well, you can have confidentiality agreements and also non-compete clauses in the contract, but many of these are also included in the law already. So there is a statutory obligation to keep everything confidential during the employment in the law. So the company is free to include such a clause in the contract, but not necessarily such a clause is needed. There is also an obligation in the law to not compete during the employment. It's a difference if we talk about once the contract came to an end. Then, of course, only we know post-contractual non-compete clauses, but then you need specific wording in the agreement and very basic information on that. Maximum duration is 2 years, and there is a mandatory compensation of 50% of the last remuneration. So it's really expensive, and we only recommend to have such a post-contractual non-compete clause to really very important employees because it is expensive at the end.
Thanks, Annette. Now, I know already, but I'm looking forward to hearing more about how completely different the situation is in Dublin. Melanie and Ian.
Oh, we'll be very brief, Jonathan, because there are huge similarities between Ireland and the UK when it comes to hiring, and particularly in relation to senior executives. We are English speaking. We have a common law jurisdiction, so the same as yours. We don't have a labour code like the French one, and we don't have the same system of collective agreements. So it is all about the contract. Now, we do have legislation, as you do in the UK, which sets out the very basic minimum terms that have to go into a contract, name and address and salary and notice, those kinds of very basic things. But after that, the parties to the contract have freedom to negotiate, and our contracts actually look and feel very, very similar. We have a minimum wage. It's €9.25 per hour, but obviously if we're talking about senior executives, that's neither here nor there. And our contracts would typically include the kind of confidentiality provisions, intellectual property provisions, and post-termination restrictive covenants that you would be familiar with in the UK. And in fact, our law around all of those issues is to a large extent based on UK precedent. So very, very similar. When it comes to recruitment, the only real kind of statutory obligation is to make sure that you don't discriminate on the grounds. Again, something you'd be familiar with in the UK. In terms of global mobility, it's quite easy to secure permission to work here. In fact, if somebody's earning over €65,000, it's very straightforward. And our applications are actually not as expensive as yours. I think the usual fee is €1,000. Sometimes it's €1,500. So quite cheap, and those permits last a couple of years. And after 5 years, the need to have a permit actually falls away. I suppose in comparison to kind of France and Germany, our social security rate's quite low. It's about 10.75% employer contribution on top of the cost of an individual salary, but that's the only additional cost over and above the gross salary rate. So actually could potentially end up being more expensive than Germany, but nowhere near where the French is. And then the only other thing that I would say, which is one of those issues that we always have to talk to UK-based employers about, and one of the significant differences, is that we don't have the opt-out from our working time regulations that you have in the UK. So the cap of 48 hours per week applies to senior executives. Now, if I told you that every professional services firm and every tech company in Dublin was limiting the hours of work of their senior executives to 48 hours, I would be lying through my teeth. So while it's there, and while there is a stick in the legislation if an organisation is prosecuted or if somebody makes a complaint, it tends to be honoured for senior executives more in the breach than it is in the observance. So that's about it from an Irish perspective, unless you have any questions.
Thank you very much. I feel very at home, particularly with the quote there from Hamlet, which my son is just studying for A-level, just as I did before him.
And me too.
So thank you very much for that. Let's move on then to the next question, which is how easy or expensive is it to let people go? And the situations that I'd like us to focus on, if possible, are the cases of poor performance or redundancy, as we'd say in the UK, if you just don't need somebody to do the job. No doubt there will be procedures, processes to follow, prices to pay if you're firing somebody for gross misconduct. And each of us will have different views, slightly different views on what gross misconduct will be. But actually, it's not a situation that in my experience, companies come across every day, whereas poor performance and surplus capacity are. So they're the ones I think that we're going to focus on. And let's start this time, if we may, Annette, with you in Frankfurt.
Okay, I was quite happy to answer your first question with a clear yes, it is easy to employ somebody. I don't want to say it's easy to fire somebody, but it's possible, and we certainly can manage it for the two reasons you mentioned, poor performance and redundancy. None of this is recognized in German law. I mean, I understand what redundancy means. I also understand what poor performance means, but just to let you know, the law does not reflect it. How do we deal with that? And as I said, we can deal with it. The law only accepts three reasons for termination. One is conduct related, and the other one is what we call business related. So although we don't have poor performance or redundancy in the law, we use these reasons. There are no special rules for executives, as I said earlier, not even for senior executives. Once again, only if the person has the right to hire or fire other employees, then there are some few additional rules, but let's focus on the majority of the employees. So also for senior executive employees, you need a reason to justify your termination. And if it's for poor performance, you definitely need a warning letter in advance, which means you must let the employee know this is what we expect, and you don't reflect this expectation right now. Business-related reason, that's the closest what you call in the UK redundancy, is, well, we inherited this from our socialist past. That means such a termination is only valid if the job is gone. So if there is no way to offer the employee any further employment. There is also one thing that is really particular, I believe, in Europe. That is that there are no statutory severance rules in German law. And also a termination is either valid or not valid and if it's valid, the employee leaves without any additional payment, you just pay the notice period. But if you lose, and let me say the employees are very well protected, so it's quite difficult to justify a termination. But if you lose, then the employee has the right to return. And we are serious by this. So that means the judge does not have any option to say, okay, I understand that's a poor performer. Termination is not really valid, but I oblige the company to pay a certain amount of money and then the employment comes to an end. No, this option does not exist. So that means it's either black or white, you win or lose, or, and that's very often the case, you negotiate something with the employee. That's of course possible at all stages. That's a very easy process, but that means on the other side the company has to pay a certain severance indemnity. I already mentioned that you have to pay the notice period. I mean, it's common to have notice periods. We have mandatory notice periods in the law. They start with 1 month and go up to 7 months at the end. Germany knows the principle of garden leave, so it's possible to send the employee home. It's not really usual, or it's not usual at all, payment in lieu of notice. So to shorten the notice period and pay the employee the remaining amount, that's completely unknown in Germany. And I mentioned earlier our famous Works Council and said that you need their approval to hire somebody. Now to end my little speech with a positive point, you don't need the approval of the Works Council to fire somebody. Sounds strange, but it is like it is. You only must inform the Works Council.
Thanks, Annette. So again, if I'm hearing this in the UK, then what I'm learning is very different. Is that there isn't anything like the hoops that you have to jump through in the UK in terms of process, but that actually employees are quite well protected, are quite well dug in despite this. And although we can't provide any sort of formula as we can in the UK for calculating how much compensation we might have to pay to an employee to get them to agree to leave or to drop any claim against them, it is possible to have that negotiation. Now in the UK, and I would say that you could solve, and I go so far as to say 95 to 99% of employment terminations by paying between 3 to 12 months remuneration to the employee. Do you have a similar range in Germany? Is it more or less generous than that when you're negotiating these settlements?
There are standard formulas around, yes. I am a little bit hesitant to say that we can solve 95%, but we can, I would say between 80 and 90%, yes, of the cases are solved by a settlement. We use usually a formula that is between half monthly up to 1 monthly salary per year of employment with no limits. So depending how long the employee has been with the company, the amount goes up. So there is no limit, as I said, by 12 months, but assuming, many employees don't work like 20, 25 years for one company, we come close to your number. One thing I did not mention earlier is that it's quite popular to fight against the termination in Germany, but the employees only have 3 weeks to go to court. So that gives companies some certainty that after 3 weeks, they know if the employee went to court.
Thank you. So a very different way of looking at things, but it is still very obviously more than possible to get things done. Valerie, what's the story in Paris?
I'm afraid it's going to be slightly different in terms of money and process, as you would have expected, of course. Let's begin with 2 differences that we have that I've always been asked by my international contacts about termination. A is in France, we don't have this garden leave concept, which means that sometimes, if not always, my contacts outside of France are very surprised when I say to them that if you release someone from his notice period after his termination, is okay to be at home and paid, because it's very common. It's different from a German perspective. It's very common to release someone from his notice period and ask him to stay at home. But the major difference is we don't oblige the employee to do something in their garden. In other terms, they can work for another company during this period of time, which seems kind of weird, if not scary, for non-French businesses. So that's the first major difference, I would say. And the second one is during negotiation rounds, there is no without prejudice concept on the French law as well. So it's kind of complicated to discuss the settlement in France when you're not between lawyers because of this non-without prejudice discussion, meaning that anything that you say between employee and company can be revealed before an employment tribunal later on if no discussion has been finalized. So that's I would say, the two major differences in terms of process. So back to how we do to terminate people. It is possible to terminate employee in France as long as you know the majority of the rules of the game that you're about to play, because otherwise you're probably 100% sure that you're going to lose the game and probably ultimately lose a bunch of money and a zero on the check. So what are the rules in these funny games? There's three ways of terminating an employee in France. One for personal reason, which is related to performance or disciplinary problems. And one other reason is for what we call economic reason, which is not linked to any personal behavior, but to the situation of the company and the group and the activity and the sector where the company is located. So that's for the two major termination ways. We have a third one since 2008, which what we call rupture conventionnelle, mutual termination, which is a kind of agreed divorce between company and employee, where there's no letter with no grievance that has to put in the letter. It's basically a discussion held between, as gentlemen, let's put it that way, between company and an employee about the fact that they both agree of leaving the business and both agree about the financial consequences. So this is the main three and the only three way of terminating someone, apart from resignation, of course, but as resignation is not very common in France because, well, specifically since 2008, because we have this mutual termination. The process is kind of straightforward. Invitation to preliminary meeting where you discuss the fact that you want to discuss with the employee the fact that you're not happy with his performance, or the fact that you have economic reason that triggers you to implement a redundancy process, either individual or collective. At this stage, and it's very important that this thing is compliant. At this stage, the company is supposed to not having taken any definitive decision. So at this stage, we're only thinking about and contemplating, but we're not deciding anything. So that's for the process. For the payment that has to be made in respect of termination, this is quite straightforward as well and quite common in the three different way of terminating people, which is trial periods. Either you ask them to work the trial period or you release the employee to work this, notice period. Mandatory and minimum severance, subject to as well collective bargaining agreements. The average, I would say, is between 20% of monthly salary for each year of seniority to 30-40% of monthly salary per year of seniority, depending on the collective bargaining agreement. The minimum is 20%, and it's in the labor code. And then, of course, you have to pay the outstanding paid vacation that's still in the books for any employee. So once you have followed the process, once you have agreed or not agreed, like decided to terminate the employee, you have to know that probably if you didn't reach any agreement before, or if you didn't make the mutual termination, I would say 95% of the termination goes to employment tribunal, actually. So this is the kind of same statistics, but not for the same results and outcomes. The employment process in France before the employment tribunal is very straightforward, very quick. It's nothing compared to anything you might have heard about in the UK in terms of length and complexity of the process. We are talking about roughly 2 hearings. The first one is a conciliation, and it lasts about 10 minutes, basically asking your name, company, seniority, and ask the employee and company if they want to agree on something. And then the real one, which is for us a long one, if it lasts for about 2 hours, which is very different from what I know from a UK kind of process. So if you don't agree on settlement agreement before the end of the process, it's very, very highly likely that you will go before the employment tribunal. So what goes there? What kind of damages you might expect if A, you have not documented enough the poor performance, and this is something really important when you contemplate to go that route. Document the thing, annual review, individual review with rating and everything to be sure that we have something to discuss before the judge. And it's the same with the economic reason. Everything has to be documented and everything has to be put specifically, clearly, and precisely in the termination letter. In terms of damages, we have a minimum for employee with more than 2 years of seniority in company of more than 11 employees, which is a 6-month damages if the termination is not justified or not done in a correct way in terms of demonstration of the facts. We don't have a formula that you're familiar with in the UK, although since last November, we have indicative table for conciliation agreements and for damages. It's only indicative. We are expecting to have new law, as you might know, in the following weeks or months with our new president and government. But still, as we speak, it's still indicative. And it goes from basically 2 months to 24 months damages if you decide to conciliate, meaning that you go up for the second round. Before 1 year of seniority, it's just 2 months, but it goes to 24 months if you're more than 30 years of seniority. So that's the kind of indicative scale that we have. And if we fight for it, meaning that we don't find a settlement agreement, then the company and the employee can agree on the fact that the judge will apply the indicative scale, and it goes from roughly 1 month to 22 months in terms of damages if you fight for it. But it's still indicative. So back to, and to summarize my couple of minutes on termination on the French law, I would say that we managed to negotiate probably not 95% of the termination we make, but I would say between 50 and 60, 64%. And it's definitely not between 3 and 12 months. I would say it's between 6 and 24 months. So yes, it might be not more complicated. The employment tribunal process might be easier and not as time consuming as it can be in the UK, but I'm afraid it's still more expensive.
Thank you, Valerie. There's no getting away from that in terms of numbers. I think the lesson is it can be done. I think there is a myth that terminations are not possible in France, and they clearly are. but that it's going to cost more money, although in practice, query how much more money in real terms than we would spend for senior executives in the UK in any event. Melanie and Ian, how does it work in Dublin?
Thanks, Jonathan. I suppose the first thing to say in Dublin is that our position is, like we said before, very similar to the UK. So there's going to be a lot of kind of familiar concepts and practices that I'm going to outline to you, but there are some important differences. One quick clarification, in Ireland we don't have works councils, so they don't come up for discussion. Looking at your question, Jonathan, I'm going to kind of divide my answer into redundancy, which is very similar to the UK, and exit or dismissal. On redundancy, first of all, we have statutory definitions very similar, but not the same, but very similar to UK, so there's no point in wasting time on those. Just in practice, there is very little challenge upheld by tribunals, employment tribunals and courts in Ireland to an employer's decision that an employee is redundant. That's seen as really something that the courts and tribunals tend not to second guess. Yes, there can be challenges, for example, around fair selection for redundancy, but it's very, very seldom there's a challenge to the actual decision to make redundant. We have, a clear division, as you do have in other jurisdictions, between individual redundancies and collective redundancies. I just want to say a word about each of those. First of all, around consultation. There is no statutory requirement to consult on non-collective redundancies in Ireland. But while there isn't a statutory requirement, it's something that we would always advise an employer to do, because it doesn't look good if an employer just imposes an individual redundancy without some consultation. As regards the kind of type of consultation, the kind of stepped approach that you would use in the UK is exactly the same as the one that we would recommend and use in Ireland. And I don't really need to, kind of give the details around that, because UK HR people would be very familiar with that. On the collective redundancy, there is a statutory requirement to consult, but it's only 30 days, which I think is significantly less than in the UK. There are similar provisions around appointment of staff representatives. If you do have an entitlement to a redundancy, the qualifying period is 2 years service for a statutory redundancy entitlement. Statutory payment. And the amount is 2 weeks pay per year of service plus a bonus week. But that's capped at €600 per week. So 2 weeks per year plus a bonus week, capped at €600 a week. Now, when you're dealing with, and we're looking at senior executives, it is very usual that if you're dealing with the exit of a senior executive, whether that's for redundancy or for dismissal or exit, that statutory entitlement is enhanced with as we would call it, an ex gratia payment. And that, if you are paying over and above the statutory entitlement, it is always the practice to get what we would call a severance agreement signed to get rid of any possible claims. And I'll talk in a few moments, just before I finish, in relation to some provisions in Ireland around severance agreements, because they're important. A few comments about exit, which is not redundancy. And again, an awful lot of what I'm going to say will be very familiar to people, listeners from the UK. We have unfair dismissal legislation, and our qualifying period is what used to be the position in the UK, 1 year before you moved to 2 years. 1 year in Ireland. There are limited exceptions around dismissal, pregnancy dismissals and trade union membership, but essentially it's 1 year qualifying period. The redress that you can get from if you have been unfairly dismissed, again, is similar to the UK. In theory, there is the possibility of reinstatement, but it's incredibly rare. The much more common redress is compensation. And the maximum compensation is 2 years financial package. Technically, you're compensated for your loss, and that has to be proven in a claim. And that's past loss. That's loss from the date of your dismissal up to the date of your hearing, your claim is heard, and an estimated sum for future loss. There's no cap on the 2 years remuneration. Now, just in practice, there has been a fall in the last couple of years with awards and therefore with settlements, because settlements tend to follow the kind of route that an award would take. And that fall is really related to the fact that the Irish economy has improved a lot in recent years, and therefore there's an expectation that people are going to be able to pick up alternative employment, so their future loss is not seen as so significant. There are 3 stated reasons in the legislation for trying to justify dismissals. Again, probably similar to the UK: conduct, competence, and capacity or fitness. Just in relation to competence, it's absolutely necessary in Ireland on a competency dismissal to go through procedure. It's procedure, PIPs, performance improvement plans, review of performance improvement plans. Melanie and I were just saying neither of us has ever come across a case where a competency dismissal was justified without going through process. Around conduct, we have stringent requirements in practice. They're not set down in legislation, but in practice around fair procedures and natural justice. We have a concept called constitutional justice because we have a written constitution in Ireland. So very stringent requirements around fair procedures and natural justice. A couple of things we have, obviously, whistleblowing legislation with 5 years maximum compensation. We do have garden leave, because I was hearing that doesn't exist as a concept in some jurisdictions. We do have garden leave. Very frequently it applies to executives. One important thing is that we don't have, like Valerie was saying in France, we don't have any recognition of the so-called protected discussion. So all discussions technically are on the record, but they take place all the time. Obviously there's a risk that you're going to end up being quoted in a subsequent claim, but nonetheless they take place. It's just that they have to take place we have to do them very carefully. I said a few minutes ago, I'd say one final word in relation to what we call severance agreements. If you are exiting a senior exec and you've actually reached an agreement with them, we don't have a kind of a statutory form like you do under the ACAS provisions. It's basically just plain contract law. But our severance agreements look extremely like your severance agreements in the UK, the same terms and conditions, and they're enforced by the courts pretty rigidly. If you sign an agreement, particularly if you've got independent advice, there's really no going back for an employee. So that's the situation in Ireland.
Thank you very much, Ian. There's one really important takeaway for me from that, and I think for our audience. But before I come back to that, the sort of rule of thumb in the UK that I proposed, you can get 99% away for 3 to 12 months money. Can you make any similar sweeping proposition in Ireland?
I would think, we were just chatting while you were talking about that, I would think it's largely the same.
It might be closer Jonathan, to the 12 months end of the scale simply because our legislation provides for larger compensation than yours does when we don't have the £70,000 sterling cap. So it is a mechanism that's available and useful to senior executives on significant and substantial remuneration packages. So largely, actually, it's not unusual to do a deal for 3 months, but likewise, it's not that unusual to pay 9 or 12 months. And for senior people, it'll probably be closer to the 9, 12, maybe even a little bit more end of the mark.
I mean, obviously, Jonathan, if there's any fault, whether that's conduct or competence on the employee's part, that tends to have an important impact on the size of the settlement.
And likewise, if an employer wants to plough on in complete breach of process or any observance of the right to natural justice and fair procedures, they will pay handsomely for that privilege.
Oh, yes.
Also known as the US employers.
Yes, quite so. And we've all seen examples where our general caps have been absolutely busted by that sort of behaviour. But the really interesting takeaway for me from that and from Valerie's talk was the absence of without prejudice or protected conversations. And you, of course, can still get to the same result in both countries, but you clearly there is a new skill to be acquired for line managers and HR managers in doing having those conversations in the right way.
Absolutely.
And that's I think a big bear trap in both countries for anybody moving there from the UK. But if we could now move on, and we did say we would be touching on this briefly, and we do have a couple of questions from the audience which have come up, which I'd like us to have time for, is how easy is it to outsource part of our business? How does TUPE work, to put it technically, in each of your countries? And here I would like to start with Ireland, if I may, because I think, in the words of the great American philosopher Yogi Berra, it is the same but different.
Exactly. It is. I've written down those exact words, same and different. We've implemented the Acquired Rights Directive, as all of the European countries have. We use the acronym TUPE to describe our regulations, as you do in the UK. And when it comes to general obligation to elect employee representatives, go through an information and consultation exercise, protection from dismissal, protection around changing terms and conditions of employment, all of that is the exact same in Ireland to the UK. Where we differ, and we differ quite significantly, is when it comes to outsourcing. And when I talk about outsourcing and you talk about outsourcing, we mean outsourcing, insourcing, change of contractors. And we are in Ireland much closer to the European position than we are to the UK position. And that is that the TUPE regulations, the Acquired Rights Directive in the other European countries, don't automatically apply when part of a business is being outsourced or where there's a change in contractors. And the application of the TUPE regulations has to be triggered. And the question for us as lawyers and as advisors, and I expect Valerie and Annette will say something similar, is always, does TUPE apply or does it not? The test, and it's a European Court of Justice test, as to whether or not TUPE applies when a function is being outsourced or insourced or where there's a change in contractors, is whether there's a transfer of significant tangible or intangible assets, or a transfer of the major part of the workforce in terms of skills and numbers. Now that has led to kind of two avenues, two schools, not two schools of thought, a very consistent school of thought, but two kind of case law lines, if you like. One is a line of case law that looks at what we call asset-reliant functions or asset-reliant services. And by asset-reliant, we mean a function or a service that, exactly as it says in the tin, is asset-reliant. So something like distribution, so you need lorries to distribute a product, or a bus service, you need buses to carry people and to provide a bus service. And when a function or a service or a business is asset reliant, in order for TUPE to apply, or the Acquired Rights Directive to apply, the assets that form the basis for that function or that service have to transfer from one entity to another. And in the absence of the transfer of the assets, in the absence of the transfer of the buses or the lorries or the trucks, then even if there's a transfer of some of the employees, TUPE does not apply. So in short, for TUPE to apply in a business that's reliant on a physical asset, even if that's an intangible asset, the asset itself has to transfer, or the assets have to transfer, plural. That's not the same when it comes to a business which is, or a service or a function which is labour intensive. And by labour intensive, the common examples are, cleaning, security, and actually for us in business, more often than not, something like call centre or IT assistance or business process outsourcing, administration. So when organisations change their contractors, or when they decide to outsource those functions or insource them, then in order for TUPE to apply, there has to be a transfer of the major part of the employees in terms of skills and numbers. So even if ancillary assets or kind of minor assets are being transferred, if the majority of the employees don't go, then TUPE doesn't apply.
Right.
And I think that's the best way of explaining the difference between how we apply TUPE and how I believe and I understand you apply it in the UK. And Valerie and Annette I'm hoping will agree with me. I think it's probably much closer to how they operate than to how you operate.
Well, I'm hoping they will agree with you too, because we're running quite tight on time, and just in the way of these things, we've got another couple of questions which the people who are listening in have asked, which I'd really like to move to. So, can I be really tricky and ask first, Valerie, is outsourcing in your country closer to the UK or to Ireland, would you say, having listened to that?
Yeah, very much actually. The only question is, do we have a business, what we call economic entity that is transferred as well as the outsourcing process? If the answer is yes, then the employee will be transferred with a term and condition on a mandatory basis. If the answer is no, they will stay within the company and not being transferred to the service provider. But it's never a black or white question, as always in France. It's always a difference of grey. But basically, this is the same kind of concept. Although we don't call it TUPE, we have our own labour code article stating implementing the EU regulation in this respect.
So. Thank you. And Annette, similar perspective for you?
Very short. I fully agree with what Melanie said. I sometimes thought she's talking about Germany. I just wanted to add that Works Council is not involved in this process. So
thank you.
Easy.
Thank you. Now, we might just overrun by a couple of minutes, but as I say, there are 2 or 3 questions which I think it would be really interesting if we could ask. A question for Valerie and for Annette. Is it possible for a UK entity to employ someone directly in each of your countries, or do you need a local branch or subsidiary?
No, you don't necessarily need a local branch or subsidiary to employ someone under a UK employment contract, actually. But as regards France, the only thing that you will have to be careful about is the employee going to be a French resident and working in France? Because in this situation, you might have to have a bureau de liaison, what we call it, which is not a branch, not a subsidiary, but just an office to be sure that you're properly registered in terms of social contribution. So that's the major thing. The second thing would be that under the Rome Convention, you have to apply specific mandatory provision of French employment law if some of the work is performed in French, which is basically minimum wage, working time regulation, paid vacation, and to a certain extent, termination provision. But in short, the answer is yes, it's not mandatory to have a subsidiary or branch to employ someone under a UK contract.
Annette, what about Germany?
Very brief again, no need to have a branch or anything. You can employ people directly by the UK entity.
Thank you. And the same question to both of you. Are there any further restrictions on hiring and firing in the financial services sector? Annette, with Frankfurt bidding to take over, as it were, from London, what's your view?
We hope that we, as I said, I'm a local from Frankfurt, so we hope to take many of the bankers, I may say, back to Frankfurt, as I said, capital of the European Central Bank. I know Frankfurt is not as attractive as Dublin or Paris might be, but I mean Frankfurt is the heart of the German, I might even say continental European banking market. So the city is all about banks.
Any restrictions, any additional restrictions on hiring or firing in financial services? No.
We love them.
For France, I would say no, except deeper investigation allowed in terms of criminal records or that kind of thing. But this is a kind of detail as regards the French employment law. So I would say no, it applies to everyone, including financial services.
Okay, there's a question here which I'm not sure I fully understand, but let me have a go. How easy is it or difficult to move people from one entity to another in each of your countries? So I'm guessing transferring people between companies in groups. Let's start off in Dublin for this one. Melanie and Ian, how simple is that?
Very. There you go. Is that short enough for you? Very.
Yep, that'll do. That's perfectly short enough, thank you. Valerie?
Depending on what you have in the employment contract, meaning if you have a mobility clause or not. If there is a mobility clause, then it's kind of easy because that means that the employee have agreed in advance to the fact that he might be asked to move in other company of the group, provided that at the time you sign the employment contract and this clause, he knows exactly where he can be transferred. If there is no mobility clause, then you touch a substantial part of the employment contract, which has to be agreed with the employee. So in short, if the employee agrees, it's a go. If he refuses, it's a no-go.
And Annette?
Same answer as in France for Germany. You really do it the same way. If there is a mobility clause in the contract, easy. If there is no mobility clause, well, you are stuck to one employer.
Very clear indeed. Thank you very much. Well, it just remains for me to thank each of Valerie, Annette, Melanie and Ian for taking part. You will see all their contact details are up on the slide in front of you now.